Good morning. Welcome to the November 8th session. And we usually start with a prayer, and our minister couldn't make it today. So, Commissioner Painter, you want to do the honor?
Be honored to do it. If you're so moved, please stand and bow your heads and prepare yourself for prayer. Lord, we thank you for this beautiful day that the Lord has made, and we thank you for the opportunity to live in a free nation, one that's guided by your hand and one that's blessed by you. Lord, we ask you be with us today. Give this board wisdom. Give those who participate in this meeting wisdom, that we might make decisions that are in the best interest of Clermont County to make it a better place to live, work, and raise a family. Lord, we ask you to be with those who are in the uniform of the United States of America today to secure our freedoms. And Lord, put your hand on those and keep them safe, that wear the uniforms of our sheriff's departments, our local police departments, our first responders and firefighters. Lord, we know that they put their lives in jeopardy every day that we might have a safer place to live. We ask you to be with those who are ill and afflicted, unable to be with us today. We ask that you heal them, that they might be able to join us at a later date. Bless all the families that are employed here in Clermont County. It's in Jesus' name we pray. Amen.
Amen. Thank you. Commissioner Corcoran, lead us in the pledge.
I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay. First on the agenda is the approval of the regular session minutes of November 1st, 23. Do I have a motion?
I'll make the motion.
Second.
Roll call, please.
Commissioner Corcoran,
Yes.
Commissioner Painter,
Yes.
Commissioner Batchelor.
Yes. Item C is public participation, and I don't see anyone in the audience. Item D is consent agenda. Board, we've had this in time to review. Do I have a motion to approve as presented?
So moved.
Second.
Roll call, please.
Commissioner Painter,
Yes.
Commissioner Corcoran,
Yes.
Commissioner Batchelor.
Yes. Item E is non-consent agenda. Item 14, it is the recommendation that the Board of County Commissioners adopt resolution number 161-23, resolving to approve payment to vendors in the total amount of $2,423,789.38 as set forth in the BCC approval invoice report for checks dated November 8, 2023, BCC directed prepaid invoice report and or the procurement card transaction report as presented by the county auditor on November 6, 2023, and further authorizing the county auditor to issue warrants for same pursuant to section 319.16 of the Ohio Revised Code. Do I have a motion to approve?
I'll make the motion.
Second.
Roll call?
Commissioner Corcoran,
Yes.
Commissioner Painter,
Yes.
Commissioner Batchelor.
Yes. 15, Gail, you got this one?
Yes, this is a recommendation to approve the request submitted by Stephen Gettinger, attorney at law, for and on behalf as agent of the petitioner to withdraw the petition for annexation of 0.792 acres from Williamsburg Township, Clermont County, Ohio, to the village of Williamsburg. It was filed in our office on Wednesday, September 5th, 2023, and this was withdrawn for issues relating to notification of adjoining property owners for the annexation. And further, that the public hearing that was set for today at 11 o'clock be canceled accordingly.
Okay. Do I have a motion?
I'll make the motion.
Second.
Any discussion?
None.
Roll call.
Commissioner Corcoran,
Yes.
Commissioner Painter,
Yes.
Commissioner Batchelor.
Yes. Item 16, Connie?
Item 16 is the recommendation to rescind the motion previously ratified by the Board of County Commissioners on July 19th of 2023, which resolved to authorize the execution of the Local Workforce Development System Subgrant Agreement by and among the Ohio Department of Job and Family Services and local Area 12 representatives, including Butler, Clermont, and Warren County Commissioners, who are the chief elected officials of the local Area 12, the Local Workforce Development Board for local Area 12, and the Warren County Board of Commissioners as the fiscal agent for local Area 12. By Clermont County Commissioner David L. Painter in his capacity of Clermont County's representative on the Area 12 Chief Elected Official Consortium, and in lieu thereof, acknowledge the execution of the revised subgrant agreement by Clermont County Commissioner David L. Painter on October the 6th of 2023, with said revised subgrant agreement to define the roles and responsibilities of said parties, as well as to identify the terms, conditions, and requirements for the administration and use of the subgrant funds allocated to Local Area 12 by ODJFS for the administration of workforce development activities for the period of July 1, 23 to June 30th of 25, for a total subgrant agreement amount not to exceed the amount specified in the ODJFS allocation letters in accordance with the Workforce Innovation Opportunity Act, the authorizing federal statutes, and the funding agreements for each funding source authorized under the subgrant agreement pursuant to the terms and conditions specified therein and in accordance with Section 5101.20 of the Ohio Revised Code.
Thank you. It's a long one.
It was.
Board, we've had the reading of item number 16. Do I have a motion to approve?
I'll make the motion.
I guess I have to second that. Roll call?
Commissioner Corcoran.
Yes.
Commissioner Batchelor.
Yes.
Commissioner Painter.
Abstain.
Thank you, Connie. Mr. Bloom. Morning.
Item 17 is a recommendation to execute a contract for professional services between the Board of County Commissioners and Bayer and Becker Incorporated out of Mason, Ohio, for project number 6402-60236 for design services for the Nagel Lift Station Elimination Project located in Pierce Township, for their proposal dated September 22nd, 2023, for a total amount not to exceed $21,212.10, with said services to be completed within 105 consecutive calendar days upon issuance of a written notice to proceed from the Clermont County Water Resources Department, exclusive of county review time and contingent upon the release of the required purchase order. So this project involves the design of about 90 feet of sanitary sewer. It's not a big project, but we'll be connecting to the new sewer that was installed in the Glen Mary Park subdivision a couple years ago. That allows for the elimination of this lift station.
Thank you. Board, we've had the reading of item number 17. Do I have a motion to approve?
So moved.
Second.
Any discussion? Roll call?
Commissioner Painter.
Yes.
Commissioner Corcoran.
Yes.
Commissioner Batchelor.
Yes. Item 18.
Item 18 is a recommendation to adopt resolution number 162-23 to certify delinquent utility charges in the amounts of $58,956.02 for sewer charges, $49,836.09 for water charges, and $4,530 for miscellaneous utility charges to the Clermont County Auditor for placement on the real property tax list and duplicate of Clermont County, Ohio, as a lien against the property served by such connections as identified in the attached exhibit pursuant to and in compliance with sections 6103.02 and 6117.02 of the Ohio Revised Code. So this will put those delinquent utility bills on their property taxes, and they'll pay them through their taxes then.
Okay. Board, we've had the reading of item number 18. Do I have a motion to approve?
I'll make the motion.
Second.
Any discussion? Roll call?
Commissioner Corcoran.
Yes.
Commissioner Painter.
Yes.
Commissioner Batchelor.
Yes. Number 19.
Number 19 is a recommendation to execute a contract for professional services between the Board of County Commissioners and Jones and Henry Engineers out of Cincinnati, Ohio, for project number 6402-60242 for design services for the Felicity Wastewater Treatment Plant Screen Replacement Project located in Franklin Township, for the proposal dated September 27th, 2023, and a total amount not to exceed $49,993, with said services to be completed within 176 consecutive calendar days upon issuance of a written notice to proceed from the Water Resources Department, exclusive of county review time and contingent upon the release of the required purchase order. So the existing screen at the wastewater treatment plant is about 29 years old. It's an older piece of mechanical equipment. It's no longer operational. They'll design for the replacement of that.
Thank you, Lyle.
Mhm.
Board, we've had the reading of item number 19. Do I have a motion to approve?
So moved.
Second.
Any discussion? Roll call?
Commissioner Painter.
Yes.
Commissioner Corcoran.
Yes.
Commissioner Batchelor.
Yes. Number 20.
Item 20 is a recommendation to award the bid for granular activated carbon contactor media reactivation for the Water Resources Department pursuant to the specifications to Carbon Activated Corporation out of Blasdale, New York, for the lowest and best bid received on September 14th, 2023, for a total estimated amount of, and I'm correcting the motion because it says annual amount. This is a total estimated amount of $2,079,000, and to execute the contract relative thereto effective January 2nd, 2024 through December 31st, 2026, with the option to renew for an additional one-year period upon the same terms and conditions in compliance with the terms and conditions set forth therein, and award of bid therefore, and contingent upon the adoption of the annual appropriations for 24. So this is a 3-year contract, and that's why I needed to correct that. We won't be spending $2 million a year on GAC. It'll be that number divided by 3 is our estimated annual amount. This is going up about 46% from the bid that we received in 2020. So it's a significant increase.
Okay, thank you, Lyle. Board, we've had the reading of item number 20 with the corrections that Mr. Balloon made. Do I have a motion to approve?
I'll make that motion.
I'll second.
Any discussion? Roll call?
Commissioner Corcoran.
Yes.
Commissioner Painter.
Yes.
Commissioner Batchelor.
Yes. Thank you, Lyle.
Thank you.
Good morning, Mary.
Item 21 is a request to increase the 2023 annual appropriations in various funds. The first is for FEMA, other expenses in the amount of $2,070. This was for an appraisal and a hazard mitigation grant. The Disability Residential Fund for DD for $200,000, and that covers additional placements. The Sheriff's Continuing Professional Training Fund is a grant from the Attorney General's office in the amount of $28,211.68. The General Fund Sheriff's Office has a $7,150 donation that they need to appropriate for. And then finally, the prosecutor and the General Fund had a retirement payout in the amount of $3,237.38.
Thank you, Mary. Board, we've had the reading of item number 20. Do I have a motion to approve?
So moved.
I'll second.
Any discussion? Roll call?
Commissioner Painter.
Yes.
Commissioner Corcoran. Commissioner Batchelor.
Yes, thank you. Moving on to item F, additions to the agenda.
There are no additions.
Wow, thank you. So the item G, the 11 o'clock has been canceled,
Yes.
correct?
Mhm.
I would recommend we move to executive
I
session.
was just going to say that, yeah.
Mhm.
We have a hearing at 11:15, so we're going to move on to executive session. It is pursuant to section 121.22G1, excuse me, of the Ohio Revised Code to consider the employment or compensation of a public employee or more public employees. Do I have a motion to go into executive session?
Before we move on that, could we just go back a second before that's moved on and just talk about, I wasn't aware those meetings were canceled today. Could we talk about why they were canceled?
The public hearing.
The
first-
public hearing.
Mhm.
That was a withdrawal. Apparently, attorney.
So we're just saying the first public
The
hearing.
first public
Got it.
hearing.
Got
Yes.
it. Okay.
Yes. Only the one for Village of
For the
Williams.
Yeah, I just thought maybe that second one, since they were both.
No, it will
Yep.
just have that at the time that it's proposed.
Got it.
Okay.
Got it.
Okay.
I was like, I thought something drastically happened.
No.
No, we're just canceling that 11 o'clock one.
So moved for executive session.
Well, then I will so second.
There you go.
I'll take that. Roll call, please.
Commissioner Painter.
Yes.
Commissioner Corcoran. Commissioner Batchelor.
Yes, we shall return. Thank you. Let her go. We have returned from executive session. Let me read one more time why we went in. It was for pursuant to section 121.22G1 of the Ohio Revised Code to consider the employment or compensation of a public employee or more public employees. No actions or decisions were made in executive session. Moving on, I counted county staff, elected official discussion. Mike Bamer.
Hello, thank you. Good morning, Commissioners.
Morning.
Morning.
Yeah, this is about celebrating America's 250th birthday, which culminates on July 4th, 2026. So today we want to talk about Clermont County considering becoming an America 250 Ohio community, which the name they're going by is AM 250 Ohio. And it's a straightforward process, and it just takes a few minutes to register. And just some background is it's a partnership between the County Commissioners Association of Ohio and the America 250 Ohio Commission. And that commission was established in law, state law. And so it's really official. They have a budget and a whole team and everything. And they're charged with preparing the state to participate in the 250th anniversary. And what they're striving toward, it's a multi-year commemoration, and to have Ohioans from communities in all of the counties to spotlight the impact that they have made or will make on our nation, and really to highlight the many firsts that come from Ohio, like aviation, colleges, national organizations, to the stories of residents and unique areas of the state. So here, obviously, one thing would be General Grant, President Grant would be a natural. And the program, they're inviting counties, cities, villages, townships, and neighborhoods to apply to have this special designation. And when you get it, the benefits are you get turnkey resources, including toolkits and online community platform, regular check-ins with other communities that are in the program to share what they're doing, what we're doing, and then recognition of our participation. So we're part of the collective bigger picture. And it's like they mentioned, it's really a simple process. You just register online to be a participant. And then once the application is approved, an email is sent to our primary contact and with a template and next steps. And I've looked at the application. It's literally like 3 lines: name of county, contact person. It's not like a long thing. So once we apply, then they'll send us a resolution, a template of a resolution that the commissioners would pass. And then with 30 days of passing that, we would designate the names of 1 or 2 individuals from the county commission office and 1 local cultural, civic, or corporate partner to be a community liaison. And I've talked to Jeff Blum. He's interested and would like to do it. And in fact, he's been involved at some stuff at the state level already with this. So, he's ready and willing. And another thing, Jeff suggested if we go ahead with this, that we have a meeting with the commissioners and various historical societies from throughout the county and him and maybe his people, and just kind of to get some planning about what we would like to do. So, that's pretty much what this is about. So I guess I could ask for your permission to go ahead and apply to get the designation, and then we could have the resolution on an upcoming meeting. And one other side note is there is a grant now with the Ohio 250 AM. I can never get that straight, but Kennedy is well aware of it. She's working on it. And there was a webinar a couple weeks ago, like a 2-hour webinar that really went into detailed steps of how to apply. And she's really savvy on that and working on that. And she's talked with Jeff to Bloom, and so that's kind of a separate issue. And Jeff thinks that this is just the first of many grants. This is just like an early one.
Get
So,
started.
right. So any questions?
Mike, I will say Judy Adams with the museum up in Bethel, she has contacted me weeks back
Okay.
wanting to know if we were going to do anything. So
Yeah.
be a good resource.
Great. Yeah. We thought of her right away.
Good.
Yeah. Yeah.
Great. We don't need a vote, do we?
We
say-
just, I would have a motion to authorize Mike to go ahead and register on behalf of the county. And then we can start there. He can register and then we'll get the resolution template after we register. Correct, Mike?
Correct.
Okay.
Mhm.
So moved.
Second.
Roll call, please.
Commissioner Painter,
Yes.
Commissioner Corcoran, Commissioner Batchelor.
Yes.
Thank you. Yeah.
Thank you, Mike.
It's exciting. I really remember
Yes.
the bicentennial.
Yeah.
Don't
And
forget the cake.
Oh,
what's that?
Don't forget the cake
Cake.
with all the candles.
Oh, yeah. Yeah. We'll be able to see that for miles around.
Ready to go.
Thank you.
Thank you.
Thank you.
Okay, anybody else elected official discussion at this time?
No, ma'am.
Okay. We have 5 minutes until we we got
20.
20 minutes.
Yes, we do.
I'm going to recess until.
That's
1:15.
right. because we don't have a-
Yeah.
Okay.
Can I have a motion to recess until 11:15?
I'll make the motion.
Second.
Roll call, please.
Commissioner Corcoran,
Yes.
Commissioner Painter,
Yes.
Commissioner Batchelor.
Yes, so we will reconvene at 11:15 for a public hearing. Okay, it is 11:15. We are back, and at this time, we have a public hearing for a annexation hearing. And I'll ask my clerk if you want to read.
Sure. Today is the date, time, and location for the public hearing on the petition for the proposed amended annexation of 175.145 acres of real property from Batavia Township to the Village of Batavia, Clermont County, Ohio. This proposed annexation was originally filed in our office on Wednesday, September 6, 2023. And it was filed as 175.7701 acres. This petition was subsequently amended by a filing on Friday, September 15, 2023, reflecting a change in the acreage to 175.145 acres, including a revised map. And this was filed by Michael Manier, attorney at law, as attorney and agent for Paul Birding, agent for the petitioners, MLO Investments, LLC, BRMI Properties, LLC, and the Crossing Church. The proposed annexation is comprised of 3 parcels of real property, all in compliance with Section 709.02 of the Ohio Revised Code. Just a reminder for everyone to sign in. If you haven't, you can do so on your way out or get up and do it now. And anyone today who is going to speak, either in favor or in opposition, will need to be sworn in by Julia Carney. She's present and she'll swear in anyone now.
Anyone that's going to give testimony today, can you stand and raise your right hand? If you think you might give testimony today, why don't you get sworn in? And you can just say, I do after the oath. I swear that the testimony I'm about to give is the truth, the whole truth, and nothing but the truth. So help me God. I do.
Thank you, Julie.
Thank you. At this time, we'll call on Michael Manier, attorney at law, for and on behalf of the designated agent for the petitioners, Paul Birding.
Gail, just a second, just
Yes.
to pause for a second. We have a full house here today. And just to make sure everybody understands, if there were any kind of emergency here in this room or anything, you would exit out these 2 doors to your back, do that orderly. There are stairwells to the north and to the south of this building that you can go down 3 stories to the ground floor. Just to make sure everybody understands that. We're not anticipating anything happen, but if we don't talk about it, then we don't know how to get out of here safely. So thank you.
And we have the fire chief here.
Absolutely.
Sorry.
Go ahead.
Good morning. It's always a pleasure to appear in front of the board. My name is Mike Manier. I am the attorney for Paul Birding, petitioner for annexation. My address is 626 Main Street, Milford, Ohio, 45150. I am anticipating that most, if not all, of the good people in attendance are opposed to the annexation. And in anticipation of that, I've prepared a memorandum for the board. You can welcome to follow along as I read. In the sake of brevity and to avoid any unnecessary annoyance, I will be not reciting the many citations to law which I have in my memorandum. So if I may, and I also want to reserve time at the conclusion to rebut any possible questions I might have of the people that testify. This petition for annexation filed pursuant to and in accordance with Section 709.02 of the Ohio Revised Code, commonly referred to as Type 1 regular annexation. Under Section 709.033A, the board is limited to 2 areas of discretion. 1, is the territory unreasonably large, and 2, whether on balance, the general good of the territory will be served and the benefits to the territory and surrounding area will outweigh the detriments to the territory and surrounding area. Regarding the general good, under Revised Code 709.033A5, the Board of County Commissioners is to determine whether the general good of the territory sought to be annexed will be served. The board's determination of general good or detriment is strictly limited to the territory to be annexed and the surrounding 1/2 mile. the board may not determine whether the annexation would be in the best interest of the political subdivision from which the territory would be detached, in this case, Batavia Township. The general good includes both the desires of the property owner and the ability of the municipality to provide adequate services to the annexed territory. The production of adequate services refers to the annexing municipality's ability to provide sufficient services for the health, safety, and welfare of the inhabitants of the territory seeking annexation. As required by Ohio Revised Code, Section 70903D, the Batavia Village Council adopted an ordinance referred to as the service ordinance, indicating what services the village would be providing to the annexed territory upon annexation. The service ordinance also provides that the village may provide additional services to the annexed territory in addition to those services specifically enumerated in the service ordinance. The service ordinance stands as competent, credible evidence that the village can, in fact, provide those services. In addition, both Ken Geis, Batavia Village Administrator, and John Theobald, Village Mayor, testified via sworn affidavits what services the village would be providing to the annexed territory. They further testified that the annexation was in the best interest of the village and that the village would not suffer any detriments resulting from the annexation. Police Chief Jim Young testified via his sworn affidavit that the property would benefit from close at hand, readily available police services and protection in addition to those currently provided by the County Sheriff's Department. Perhaps of paramount importance is the fact that this is a 100% owner annexation. All three owners of the territory to be annexed signed and filed with the board their sworn affidavits stating why they wanted their property to be annexed to the village and why they thought the annexation was in the best interest of their property. Their affidavits are part of the record and they serve as testimony to be considered by the board. None of them thought their properties would suffer any detriments resulting from the annexation. Where 100% of the owners within the territory to be annexed support the annexation, and the area will receive additional beneficial services and no resulting detriment, a Board of County Commissioners determination that an annexation would not serve the general good of the territory is not supported by the preponderance of the substantial, reliable, and probative evidence. As the board can see from the citations that I've stated on their copy, that's reference to Supreme Court cases. Dealing with unreasonably large, the total acreage of an annexation is only relevant to the unreasonably large determination if the annexing municipality is unable to adequately service the territory precisely because of its size or shape, or the size and shape of the territory to be annexed results in some detriment that, on balance, outweighs the benefits of the annexation. That is, the opponents to the annexation must show, one, that the village will be unable to adequately service the property because of its size or shape, or two, that even though the village may be able to adequately service the property, the size or shape of the property causes or results in a detriment to the property or the surrounding area that outweighs any benefits to the property. Since the village, through its service ordinance and the village's administrator, mayor, and police chief, and all three petitioners have testified that the property will benefit from the annexation, it then becomes incumbent on the opponents to the annexation to prove by the preponderance of the reliable, probative, and substantial evidence that the annexation will not only result in some detriment to the territory, but that detriment outweighs the benefits to the territory. Having participated in a great many of these hearings over the years, I can fairly accurately predict what the opponents may put forth as the following detriments. And the reason I've listed this here, basically in time, so I don't have to come back later after all these good folks have testified as to why they're opposed to it, so I don't have to come back and question each one of them and go through a lengthy rebuttal process. One of the things I frequently hear almost in every annexation is road segmentation and division as a detriment. I fully expect the township to raise the issue of dividing and segmentation of public roads as a detriment resulting from the annexation. In his September 29, 2023 letter to the board, Deputy Surveyor Craig Reisner identifies 3 public roads that will be divided or segmented by the annexation. When Craig gets up later, I'm sure he's going to hit on this in his report to the board. However, dividing or segmenting a street, road, or highway is not per se prohibited by Ohio Revised Code 709-033A6. It becomes problematic only if the dividing or segmenting of the street, road, or highway creates a road maintenance problem, and then, and only then, if the village does not agree as a condition of the annexation to assume the maintenance of the street, road, or highway. The statute does not require formal written maintenance agreement with ODOT, the township, or the county, or that the divided road or street be specified or identified. It requires only that the village assume the maintenance of road maintenance problems are caused by the segmentation or division of the street, road, or highway, which the village of Batavia has agreed to do in its service ordinance. That's all that's required by the Ohio Revised Code and any subsequent case law. Any street or highway divisions or segmentations resulting from the annexation are resolved by the service ordinance adopted by the municipality agreeing to maintain any divided or segmented street or highway. Something that is almost always brought up in these annexation hearings are the impact on schools or as a detriment. Although it has been black letter settled law in Ohio for 25 years that an annexation's impact on schools cannot be considered as a detriment, opponents of these hearings nevertheless always seem to bring it up anyway. The Supreme Court in Smith versus Granville Township Board of Trustees, which is a 1998 Ohio Supreme Court case, held that a Board of County Commissioners cannot consider impact on schools in making a general good determination. The court held, and a holding of a Supreme Court is that's the law that applies to all 88 counties in the state. The court held that Ohio Revised Code Section 3311.06 has the exclusive authority over school-related issues due to an annexation. This holding has been followed and cited as precedent in many cases since then. In fact, Judge Haddad in the recent Clermont County case McEvoy versus Board, and I've got the citation there, cited the Smith case as authority and followed its holding that issues relative to schools are not a factor to consider when making the general good determination. Another thing that always comes up, and I expect it to come up in spades today, is future development as a detriment. As in all annexations, it is anticipated the township and the good folks here will raise concerns about possible future development and issues of zoning and land usage. The 3 properties seeking annexations are essentially currently undeveloped and unimproved. The board is limited to considering the properties as they exist today, not as they may be developed at some time in an unspecified and uncertain future. Regardless of what may appear on paper as the owners and the village desire for the future development of the property, applications still have to be made and approvals received from the Village Planning Commission, perhaps the Village Board of Zoning Appeals, and ultimately Village Council. By then, the owner's plans and those of the village for the property may have changed due to a host of currently unknowable circumstances, such as the cost of labor and building materials, the state of the economy and interest rates, a change in the village administration, a change in the makeup and mindsets of future councils, BZAs, and planning commissions. As the law director of the city of Milford 44 years, I can speak that from personal experience. In the future, the village and the owners may or may not proceed to place a PUD, planned unit development, on the property or designate a CRA, community reinvestment, for all or a portion of the property, or they may agree to some other use or development of the property altogether. All which goes to show that the testimony regarding future development, zoning, and land use is highly conjectural and speculative. That same issue came up in the previous case in front of Judge Haddad, and if anybody would like to refer back to that, it also speaks on future development. The Ohio Supreme Court has held that conjecture and speculation regarding possible future problems which may result from an annexation, such as possible future development, does not constitute evidence required to show preponderance. Preponderance is the level of proof that must be shown. Therefore, any testimony relating to issues of zoning, future development, and land use are completely irrelevant and and cannot be considered by the board when assessing the general good, nor can the board consider it as a constituting adverse legal effect or detriment. So when all the good people here get up and state their opposition regarding on the future of the property, that I understand that, and I've heard it many, many times, and I can't say that I, fault them for that. Nobody likes change, but when the board makes this consideration, you're going to, the law is pretty clear on that issue. Another issue brought up frequently at these hearings, at least in my experience, is the loss of real property taxes by the township as a detriment in order to show a detriment. In order to salve and ameliorate the loss of any real property taxes to a township resulting from an annexation, the Ohio legislature enacted Section 709.19D of the Ohio Revised Code, commonly referred to as the reparations provision, in which the annexing municipality is required to pay to the township real property taxes from the annexed territory over a 12-year period. It only applies to residential retail real property taxes using the property valuation for the year that the payments are due. As your planner, Leonard Kendall, states in his memorandum to the board dated October 17, 2023, there currently is no retail or residential use of the property. The property is, for the most part, unimproved, has a CAUV designation, or in the case of Crossings Church, property exempt. The loss to the township is therefore negligible and to minimize. Detriments resulting to the township can only be considered if the reduction in township tax revenue caused by the annexation is so staggering as to threaten the township's ability to continue to function as a viable entity. Our 12th District Court of Appeals, which Clermont County is bound by their decisions and holdings. Our 12th District Court of Appeals in the Deerfield versus Bayshore case gave little weight to the impact an annexation might have on tax base of a township, indicating that while the township may have fewer financial resources after an annexation, the township will no longer be responsible for providing services to the territory. Therefore, it is incumbent on the opponents to the annexation to prove by a preponderance of the reliable, probative, and substantial evidence that the annexation would be debilitating to the township or threaten its ability to continue as a viable entity. Clearly, that is not the case in this particular annexation. Lastly, something that might be novel to this hearing that I haven't experienced that many times before, and I don't know if it's going to happen. I'm just anticipating the worst. The Batavia Village's financial condition as a detriment. In preparation for this hearing, the township served the village with a public records request, requesting, among other things, 2 years of financial statements, budget documents, documents relating to the funding of proposed future development of the property, and documents relating to the Howe Homes development. The Howe Homes development was a prior annexation that I also represented the village of Batavia on. I believe that the township may even call an accountant to opine on the financial condition of the village. I don't know if that's going to happen, but I'm preparing for anything. First of all, for reasons I have already expressed, I preemptively object to any testimony or the introduction of documents concerning or relating to any proposed future development or concerning or related to Howe Homes as being totally irrelevant and not a proper consideration for the board. I've already indicated the future development of the property is not to be considered, and that probably has something to do with the raising the financial condition of the village, I guess. And I suppose the introduction of budgets and financial statements would be in an effort to show the village's inability to adequately service the property. The village council, the mayor, the administrator, and the 3 petitioners all believe the village has a financial wherewithal to adequately service the property, and apparently they are concerned about it. I don't know if the board, I know the board has nothing to do with the budget of the village, but you may be able to take quasi-judicial knowledge of the financial condition of the village. Lastly, and then I'm almost at my conclusion, loss of township land as a detriment. While townships privately bemoan annexation as land grabs, They rarely state this in public at these hearings because they are painfully aware that it has been the longstanding policy in Ohio, as stated and restated by Ohio Supreme Court, that annexations by municipalities of adjacent territory are to be encouraged. This is especially true in 100% owner annexations such as we have here. I've always wondered how townships could presume to know what's in the best interest of the village than the village themselves would know about themselves. In conclusion, this annexation is fully in keeping with the spirit and intent of that policy, encouraging annexation, and the legislative intent to give owners of property the freedom of choice as to which governmental division in which they desire the property be located and in and governed by. I respectfully request the board to grant the petition for annexation. Thank you for this opportunity to address you, and if there's any questions, I'd be glad to answer them now or later. As I've indicated, I would like to reserve time to rebut or answer any questions after we hear all the opposition.
At this time, we'll call on Craig Reisner, Deputy Surveyor for Jeremy Evans, County Engineer. He's present to present his report on the proposed annexation. I got it.
Morning.
Morning.
Craig Reisner, County Engineer's Office. This is the reading of the report of the County Engineer. This is for proposed annexation, 175.145 acres. It's an amended plat and description for annexation to the village of Batavia. I've reviewed the plat and description for 175.145 acres of land owned by BRMI Properties, MLO Investments, and the Crossing Church, identified as parcel numbers 012006D 088, 012006F 024, and 012007E 035 on the tax maps of Clermont County. The village of Batavia currently contains 2,043 acres. The proposed annexation is 175.145 acres, and Batavia Township currently contains 24,718 acres. The territory proposed to be annexed shares a contiguous boundary with municipality for a continuous length of 281.12 feet. That works out to be 2% of the perimeter of the territory proposed to be annexed. The annexation will not create an unincorporated area of the township that is completely surrounded by the territory proposed to be annexed. So this annexation will not create an island. There are 3 public roads that will be divided or segmented by the proposed boundary line between the township and the municipal corporation as to create a road maintenance problem. 1,233.7 feet of Taylor Road, County Road 122, will no longer be maintained by the County Engineer's Office. 850 feet of Bauman Road, T149, will also be segmented and will no longer be maintained by Batavia Township. And 455.93 feet of Clough Pike, County Road 33, as shown on the annexation plat, will no longer be maintained by the Clermont County Engineer's Office. There has been a plat and legal description amended and provided by Bear Becker Incorporated, and the plat and description are complete and accurate for annexation purposes. If the board chooses to approve the annexation, a signed and sealed Mylar copy of the annexation plat will be required. Thanks.
Okay, at this time, we're going to have a request for comments. And this will be in favor of the proposed annexation. If anyone here is in favor of the annexation, you can comment at this time. When you come up to the podium, can you please state your name and your address for the record?
Is there no one?
Okay. Now we request comments in opposition to the proposed annexation. Sir, please state your name and.
Thank you. John Roach, I'm with the law firm of Frost Brown Todd. I'm here on behalf of Batavia Township. If I could approach the board, please. Excuse me.
One for the clerk.
Thank you.
Do you have this?
No, I do not.
Do you have?
Okay, thank you very much.
Do you mind speaking up just a little bit?
Sure.
I can hardly hear you. Thank you.
John Roach with Frost Brown Todd. I'm an attorney on behalf of Batavia Township. Opposed to the annexation today. Thank you, Mr. Renier, for your presentation. Members of the board, thank you for the opportunity to speak to you today. This petition for annexation must be denied because it does not satisfy the requirements of Revised Code Section 709.033. We heard a long presentation from Mr. Renier about different objections that townships have made in the past and why he doesn't think those apply here. But really what the board needs to focus on is the requirements of what the petitioners are required to prove today. And specifically, the petitioners are required to prove that this annexation serves the general good of the territory, and they have to prove both of these elements, and that the benefits to the area that's going to be annexed and the surrounding area, meaning all properties within a half mile of the area to be annexed that are currently within the township, that the benefits to those areas outweigh the detriments. This is the burden of petitioners to prove both. There has not been much evidence introduced on those facts today. The statements of Mr. Renier's counsel are not evidence. There's been no witness testimony on those facts. There are the affidavits. Now, the Ohio Supreme Court in 2020, in interpreting this requirement, the requirement to prove both of these elements, held that this is a case involving the Greene County Board of County Commissioners, an annexation petition, held that whether an annexation satisfies these two requirements is a question of fact within the discretion of the board. A question of fact within the discretion of the board, meaning that the board needs to consider the facts put before today, the testimony, the affidavits put before today, and the board has discretion. The board has discretion to rule in favor of the annexation or against the annexation, meaning that you hold the power today to determine whether this goes forward. Now, there are two reasons why this annexation does not serve the general good of the territory and why the benefits to this annexation, the benefits to the territory and the surrounding area are outweighed by the detriments. Number one is the nature and scope of the public financing that is directly tied to this annexation and the negative impact that will have on the surrounding properties. And that negative impact will be substantial. It will outweigh any benefit to this annexation. And number two, the impact of this type of development will have on the neighboring property owners. You'll hear today testimony, I expect, from neighboring property owners. I'm sure you'll hear testimony today from the airport and the negative impact that this development is going to have on the Clermont County Airport, which is within 1/2 mile of the area to be annexed. Now, to the first point, the public financing and the tax abatements that are directly tied, they are directly tied to this annexation. They weigh heavily against granting this annexation. You'll have in front of you to review. You have in those binders the pre-annexation agreements. These were entered into by the owners, by the developer, and by the village. And I heard Mr. Renier say that speculation about future development is not admissible evidence. It's not competent evidence. And I agree that speculation is not competent evidence. This is not speculation. These are signed agreements. These are signed agreements by the village, by the developer, and by the current owners, and they lay out what's going to happen if this board grants this annexation. This whole process starts and is dependent upon the annexation this morning. And the impact of the annexation on the taxes are a proper consideration for this board. Now, there's 3 steps to the annexation. The first is that upon granting the annexation, the village of Batavia is required to designate this entire annexed area as a community reinvestment area, or a CRA. Now, I'll direct the board's attention to, I have in front of you, Exhibit 1, specifically paragraph 2. It's a little hard to read on the board, but you have it in front of you. And what it states is, upon acceptance of the petition for annexation by village council, council shall pass and adopt legislation necessary to designate the annexed real property in the classification applied for by the petitioner, meaning they shall give it zoning approval, including the designation as a CRA development district. Now, CRAs are reserved by Ohio law for areas with historic structures where development has been discouraged. Areas with historic structures where development has been discouraged. You will hear testimony today that the area to be annexed has not only does it have no historic structures, it has no structures whatsoever. And in fact, the township was approached previously about this area being developed. So it's not an area with historic structures, and it's not an area, the evidence will show, where development is discouraged. So it doesn't fit the definition of a CRA. But there isn't state oversight of the CRA approval process. You apply for it and you get it. Now, CRAs are unique in Ohio in that they allow a 100% tax abatement. 100%. And there's no requirement that the applicant for a CRA obtain permission from the school district, from the joint fire district, from the county, from any other governmental entities that service this area. They don't have to negotiate. They don't have to give any payments to any of those entities. Under the terms of these agreements between the owners, the village, and the developer, the CRA in effect will be the maximum CRA allowed by law. And that's 100% abatement for 15 years. Specifically, paragraph 10, exhibits 1 and 2 are the pre-annexation agreements between all owners, the developer, and the village, and they're substantially the same documents. But paragraph 10 requires the village to enter into a development agreement that is similar to the August 19th, 2019 agreement between the village and Hal Homes. You have that agreement in front of you. That's exhibit 3. Development agreement between the village of Batavia and Hal Homes. This is in regard to, as the board may be familiar, the Streamside residential development. Specifically, section 3 of this agreement states that any CRA granted pursuant to this section and the Ohio Revised Code shall be for 100% of incremental improvement value for a term of 15 years. It's in writing, it's signed, and this is incorporated into the annexation agreements that are signed by all parties. This is competent evidence that this board can rely on to understand what is going to happen with this annexation. Now, the second step, after the CRA is granted a full abatement, 100% for 15 years, the second step is that the village is required to issue special assessment bonds, meaning take on debt and send that financing to the developer for this development. I'll direct the board's attention back to exhibits 1 and 2, this time paragraph 10. It reads, the village agrees to work with petitioner or assignee to enter into a development agreement for the purpose of creating special assessment bonds, similar to the Hal Homes agreement. Petitioner or assignee intends to use the special assessment bonds for the development of the property or a portion of the property. The board will hear today that the developer expects to receive between $6 and $7 million in special assessment bonds. And this brings me to the third piece of how this public financing is going to work. And that's how these special assessment bonds will be paid back. And that's going to be through what's called a payment in lieu of taxes, a pilot payment. Going back to the Hal Homes agreement, which is incorporated into these pre-annexation agreements, section 4, it's not highlighted there, but talks about the payment in lieu of taxes. It says that the developer and all subsequent owners shall pay 50% of the value of any taxes abated by virtue of receiving the CRA. And those shall constitute payments in lieu of taxes. Now, what's going to happen with those payments in lieu of taxes? You'll hear testimony today that those payments in lieu of taxes, the 50% that's actually collected in taxes, are just going to go back to pay off the bonds. None of that money is going to go to, and you'll hear testimony today that there's no agreements for that money to go to the fire district, the joint fire district. There's no evidence of that money going, any of that money going to the Batavia local schools. There's no evidence of that, any of that money going to the county. So to sum it up, the developer is receiving $6 to $7 million in upfront financing, and then gets to market the properties as 100% or as 50% tax abated, and then the 50% that is included in taxes goes back to pay off the bonds that were issued up front for the development. And this is all directly tied to the decision that's made today. And the decision that's made today and the impacts that it will have not only on the area to be annexed, but on all the surrounding property, all the surrounding properties. And what is this level of public financing going to support? Perhaps if this was going to support an industrial or commercial development that was going to bring in high-paying jobs and not result in a significant increase in demand for public services, well, then maybe this type of arrangement is appropriate. That's not what it's going to support. You'll see the development agreement. You'll see the development plan. Exhibit 4. This is the development plan for the annexed area, 321 homes, 6,000 square foot lots, 3 to 4 homes per acre. That is necessarily going to lead to a substantial increase in demand for public services with zero money going to offset that demand. And what that means is that for all the properties that are surrounding this area, they have to pick up the tab because their property taxes will go to pay for the public services for the joint fire district, for the school district, for the county, for this area, because this area is not going to pay anything for 15 years. So what the territories and the surrounding areas are receiving for this level of public financing is a dense residential development. That's out of character. You'll hear it's out of character with the surrounding area. You'll hear that the neighbors, the property owners around this area and the detriments to their properties are a specific fact this board is required to consider are against it. Now, if this area was solely served by the village and if the village had its own exempted school district that was going to take on the responsibility of educating all the people moving into this area, and if the village had its own fire department that was going to take on the responsibility and expense of providing fire and EMS services to this area, then the answer to these problems might be, well, it's the village's issue to figure out. That's not the case. This area is served by the joint fire district. That's a fire district that serves both the township and the village and supported by both township and village property taxpayers. And that means that all of those property taxpayers are supporting those services to this 100% abated development. Same logic applies to the schools. And I heard Mr. Muneer say that it's black letter law, that you can't consider the impact on schools. That's not true. The Ohio Supreme Court decision in 1998, the Smith decision, first of all, interpreted a prior version of 709.033, which did not require this board to make a finding that the benefits outweigh the detriments. It interpreted a different section in granting these annexation petitions. Number two, the Smith decision is based on, the Supreme Court's finding is based on, its holding is based on a determination that the revised code vests in the Ohio Board of Education the right to make these decisions. And it references revised code section 3311.06. Now, the Smith decision involved a city that was annexing a piece of property, going to put a dense development in, and that development was going to be serviced by another local school district. The city had its own school district. The development was going to be serviced by a local school district. The Supreme Court said, well, where that territory gets transferred to, that's a decision for the State Board of Education. That's not the case here. These properties are serviced by Batavia local schools, and they will continue to be serviced by Batavia local schools. This is not a case where we're talking about a transfer between school territories. This is all being serviced by the same school district. And the biggest distinguishing factor from the Smith case is the Smith case doesn't talk, there's not a sentence in the Smith case about a 100% tax abatement or 100% loss of funding to the school district. There's nothing in that case about that. So Smith is easily distinguishable. And the idea that you can never consider the impact on schools, that's simply not true. That's not supported by the Smith decision. So I promise I'm finishing up. The reality of this arrangement is that the village makes this deal, and it just passes off the costs to the other political subdivisions that service this area, and it passes off the costs. Particularly important here, it passes off the costs to the other property taxpayers who pay for those services for this area, and that includes the property owners surrounding the annexed area, and the benefits and detriments to the area surrounding the annexed area, not just the annexed area, is a proper factor for this board to weigh. Tax issues are a proper consideration for this board. I'll turn the board's attention to Annexation Petition number 103, Territory in Carryall Township, a 3rd District decision from 2005. After this section was amended, this was a 3-0 decision by the 3rd District affirming denial of a petition for annexation. And Judge Robert Cupp writes in his concurrence. He writes separately in his concurrence, I believe it is important to also state that it is entirely appropriate for the Board of County Commissioners to consider the tax consequences upon the property and the territory to be annexed in weighing the benefits and detriments. The impact of the abatement and then of the tax setup is proper evidence for you to consider in making this decision today, because it's directly tied to the annexation. It's the whole point for the annexation. This is the last time I'll refer you to these pre-annexation agreements. Exhibits 1 and 2, subsection or paragraph 2. Final sentence states, the village understands that obtaining the zoning designation and classification requested by petitioner and the obtaining of the CRA Development District designation is the primary reason for petitioner seeking annexation to the village, and therefore constitutes a substantial and material consideration for petitioner entering into this agreement. It's why this is happening. It's directly tied to it. And so this is not conjecture. It's not speculation. You have the agreements in front of you. This is what's going to happen. And it's in your hands now. And you have discretion in how to handle it. And you are going to hear from, I expect, several witnesses today that are against this annexation. And on behalf of Batavia Township, this annexation does not serve the general good. And the detriments to the surrounding area and the territory outweigh the benefits. We're requesting that you deny the annexation. Thank you.
Thank you.
Good morning.
Morning.
I want to thank the commissioners for allowing me the opportunity to speak here in public session. Keith Millard. I'm superintendent for Batavia Local Schools. On behalf of the Board of Education, over 2,500 students and families, I offer the following statement in opposition to the village's annexation request. Annexations and the associated CRAs are intended for blighted and underinvested properties. While previous CRAs entered into the village may raise to the standard inside the pre-annexation village limits, using CRAs on developable land with access to an approved 32 corridor stretches the reasonableness of using a CRA as a development tool, given the county's growth trajectory and potential. When considering the approval of the annexation and the associated CRA, the benefit of the public must be carefully weighed, as previously has been stated. And it's my belief that the CRA does not meet the standard for benefiting the public as well as the annexation. First, public benefit is not served when overlapping governmental agencies are not aligned and working jointly to serve the public. Through the annexation and CRA process, the Village of Batavia is recognizing a double tax benefit, regardless of what they choose to do with the taxes, with both pilot payments and income tax payments heading directly to village coffers. At the same time, the school district and CJ Fed are expected to serve the residents of the newly annexed and CRA neighborhoods without additional funding benefits. If the district or CJ Fed were the governmental agency with the power to create taxing structures that benefited the district or CJ Fed, while at the same time expecting the village to provide services without the associated tax benefit, it stands to reason that the village would be upset about this arrangement. The public benefit is also not served by placing an undue burden on existing taxpayers for future operational levies needed to serve the additional students and residences whose families are enjoying services without having the corresponding tax responsibility. The rapid expansion of CRAs by the village creates a negative tax environment for all residents whose homes are not covered by a CRA. Additionally, the public benefit is not served by the lack of transparency in which the village has operated with the current Bauman properties under consideration for annexation. The use of emergency actions on council agendas, the lack of communication and consultation with affected overlapping governmental agencies responsible for providing services to the increased territory of the villages results in developmental decisions that do not accurately reflect the will of the citizens of Batavia, nor the ability of educational and public safety agencies to meet the needs of those additional residents. Finally, the benefit is not served by overburdening CJ Fed with additional safety responsibilities without additional tax revenue. Currently, the school district and almost 3,000 students and staff who reside at Bulldog Place daily depend upon the coverage and fast response times that CJ Fed provides. When over 1,000 new residential units are completed at Streamside, Harvest Meadows, and the Bauman developments, response times will be reduced and the public welfare will be compromised due to CJ Fed's need to serve additional residents without additional dollars to increase staffing, equipment, and support. Clermont County is poised to be the next economic breakout county in Southwest Ohio, with the completion of the 32 corridor project in 2026. While growth is inevitable, it also must be responsible. Using annexations and CRAs to enrich the village is not responsible growth, while other governmental agencies responsible for providing services are left without additional tax dollars to provide services that are thrust upon them by the village's desire to grow through annexations and tax giveaways. It is for these reasons that I respectfully submit that the proposed annexation and corresponding CRA is not in the best interest of the residents of Batavia, and it is my request that the commissioners deny this request. Thank you.
Thank you.
Hi, Karen Swartz, Batavia Township Administrator. I'm here today on behalf of the Board of Trustees to object to this annexation as it does not serve the greater good of the territory. The area of 175 acres, which includes commercial property, if approved, this will be the second industrial property area annexed into the village and then turned into a residential development. The development proposed, as referenced in the pre-annexation development agreements and already approved by the village, will negatively affect all the property owners in Batavia Township along Clough Pike who own 1 to 5 acre lots. Additionally, there's additional industrial sites on the other side of the property too that could be negatively impacted since they're going to have neighbors or residential properties in their backyard. The proposed development of 321 homes has lots that are 6,000 square feet minimum or 0.14 acres per lot with an overall density of 3.3 units per acre. The community offers 0 amenities, lacks access to the village city center, and creates a hazard for the airport property due to the density of the development and the planned retention on the site. The Clermont County Airport is an essential partner in economic development for Clermont County and for the township. This development will potentially inhibit growth for the airport. Batavia Township met with Jeff Hayes, the developer of the project, in early 2022 regarding this actual development. And we worked separately with BRMI, which is commonly referred to as Black Rhino. We granted variances for Black Rhino for mixed-use development on their site that they requested. The bottom line is Batavia Township would have approved a development in this area, but the density would have been larger. It would look different. It would look better. It would consider the adjacent property owners, and it would consider the adjacent industrial properties, and it would also consider the airport's factors in the development. In addition to the village approving the increased density, they offer development incentives through a community reinvestment area commonly referred to as a CRA. The CRA is defined in Ohio Revised Code 3735.65. And I'll read a portion of that definition. It states that the boundaries of the area and containing a statement of finding that the area included in the description is one in which housing facilities or structures of historical significance are located, and new housing construction and repair of existing facilities or structures are discouraged. There are no structures on this property. This is vacant land ready to be developed. When I met with Mr. Hayes, the developer for the project, regarding a different project in Batavia Township, I asked him why he didn't stay in the township and why he was going through the annexation process. He stated that the village had offered him the desired density and is approving the development without amenities. He noted that the village council doesn't care about public hearing comments or what adjacent property owners think since they don't vote for them. Additionally, the village is offering $6 to $7 million in special assessment bonds to Mr. Hayes. I asked him how that worked and what the benefit was to him. He explained that the village helps him secure the bonds and that he is responsible for making the payments. Residents in the new community will pay a pilot payment directly to the village instead of property taxes. The village will reimburse him as defined in their final agreement. He stated that he hoped to be able to cover the bond payments 100%. I advised him that the schools and the fire department would not be paid in this scenario. He said the village officials told him the schools and fire departments would be made whole. I requested several public records from the village, including any contracts or agreements with local schools or fire departments. None were provided. Due to the economic development incentives, there are a total of 2,000 or more residential units that are not paying additional taxes to our joint fire district. This puts an unfair tax burden on the other taxpayers in the district. I want to close by reiterating that Batavia Township opposes this annexation. It does not serve the greater good of the village or the township, as it hurts the fire departments, schools, and the airport. It doesn't fit into the neighborhood of existing homes or adjoining properties, and these residents will not be heard after today. On behalf of the Batavia Township trustees, thank you for the opportunity to address the board today. Thank you.
Just briefly, while Ms. Swartz is up, I have a few questions to protect the record. Ms. Swartz, you saw my presentation, Exhibits 1 and 2. Were those pre-annexation agreements that you received in the run-up to this hearing from the village?
Yes.
Okay. And Exhibit 3, did that appear to be the Howell homes? You can scroll right and left.
Okay. Yes. Yeah.
Exhibit
Yeah.
3, did that appear to be the Howe Homes agreement between the Village of Batavia and Howe Homes back in 2019?
Yes.
And then if you could scroll to Exhibit 4, second to last slide.
Oh, there we go.
Sorry, third to last slide.
Oh, I think that's it. There. 4.
Exhibit 4, was this the development plan that you received for the proposed development for this property?
Yes,
Okay. And who did you receive that from?
from the Village of Batavia.
And Ms. Swartz, briefly, who provides fire and EMS services to this area?
The Central Joint Fire and EMS District.
Thank you.
You're welcome. Thank you.
Did you retain somebody to review the village documents that you received?
That was handled by our attorney.
Did you hire an independent accountant or CPA to review those?
That was handled by our attorney.
So it wasn't handled in-house, you referred that out to your attorney?
Correct.
And is that the same gentleman that's spoken here today?
Yes.
I move to strike the entire testimony regarding Jeff Hayes as being irrelevant for the reasons I've already stated in the memorandum of law. It's hearsay. This is a quasi judicial type hearing.
I object to that testimony being struck. It's an administrative hearing. The rules of evidence do not strictly apply. And Mr. Hayes is, on behalf of the developer here, here's an adverse party. So even if the rules of evidence did apply, it'd be a statement, it'd be an admission of an adverse party. It would be admissible evidence, even in a court of law. So ask that the objection be struck.
Thank you, Karen.
Thank you.
Kevin?
Good morning, Commissioners.
Good morning.
How are you? My name's Kevin Riley, and I'm the Fire Chief with Central Joint Fire and EMS District, which covers Batavia Township and Batavia Village. This isn't the first time I've spoken to the board about annexation, but this is the first time that I've spoke to the board about annexation as it relates to a community reinvestment area. All other annexations I've testified about were approved, but at what cost to the community? Me being the fire chief, it's fire and EMS service and our budget. I've been a fire chief since 1995, and I've been here in Clermont County since December of 2001. I've watched over the years government chipping away at emergency services funding that the voters of the district clearly voted to be distributed to the fire and EMS district. Given this annexation, an additional 321 homes that will not pay taxes to the fire and EMS district when it's voted in millage. In my opinion, that should not be allowed, or it should be supplemented by the pilot payments, or it should be supplemented by the 1% income tax that's going to be collected from the residents who live there. According to the state of Ohio, community reinvestment areas are designed geographical areas where local governments offer incentives and tax benefits to encourage economic development, job creation, and property improvement. While CRAs can be a valuable tool for revitalizing neighborhoods and stimulating economic growth, they also come with potential pitfalls and challenges. Here are just some associated with the CRA. Revenue loss for local governments. By offering tax incentives to attract investment, CRAs can result in short-term reduction in local government revenue. This loss can strain public services and infrastructure if not managed properly. This CRA, to my knowledge, is for 15 years. That will allow the current taxpayers to carry the burden of others who are going to be inside this new development. Environmental impact. Rapid development of CRAs has an adverse effect on the environment, such as increased pollution, loss of green space, and strain on resources, including local school districts. There's some unintended consequences of CRAs that lead to traffic congestion, higher living costs, and changes in the character of the neighborhood. Comprehensive planning and impact assessments are necessary to address these issues. The CRA is being used for tax abatement, but the village is still going to receive a 1% income tax from the folks who live within those geographical boundaries. I believe that it's the responsibility of the folks who are annexing the land to make the fire district whole, whether again that be through pilot payments or that be through the 1% income tax. So thank you for allowing me this opportunity to speak with you today, and I hope you have a great week.
Thank you. Thank you, Chief.
Actually, a question here. Were you fire chief when Governor Kasich was governor for the state of Ohio?
I've been a fire chief since.
Hold it. Who are you?
Oh, I'm sorry. Yeah.
He can't ask
Yeah.
questions.
Okay, I'm sorry. I'll ask it when I get up to the podium. I apologize.
I guess you
Morning, Chief.
Good morning.
I respect your service.
Thank you.
Do you currently service the village, correct?
That's correct.
And if the annexation is granted, you will continue to service the village?
That's correct.
Also. Okay, and you, in good faith, you stated your opposition to CRAs. I understand how that works. There's not currently a CRA designation on the property, correct?
As far as I know, that is correct.
And in the past, when the village has applied for CR designation on other property, have you shown up to object?
I did to village council.
Okay, so that is the time for you to state your objections at that time when the actual application, as it were, is before the village. At that time, you come to show it and object to your the CRA, correct? You do that then.
Objection.
What's the objection, so I can respond?
Calls for a legal opinion on when the appropriate time for an objection to CRA is. Ask for evidence outside of witness personal knowledge.
In the past, have you appeared before village council to object to the CRA?
Yes.
Okay. And that's when you show up, when it's before them, correct? You personally show up at that time, correct?
I show up when I'm asked to show up.
Okay, thank you. Great answer.
Any more? Yes, sir. Please remember to state your name and your address.
Don't mess up the keyboard.
You can put it underneath if you like.
All right.
Yes.
Chuck Gallagher, Clermont County Airport, president of Eastern Cincinnati Aviation, also the airport manager. Everybody hear me okay? Yes. All right. Commissioners, thank you for allowing us to speak today. So Eastern Cincinnati Aviation is the manager of the Clermont County Airport and strongly urges the board of the Clermont County Commissioners to deny the annexation of the 175 plus acres from Batavia Township to the village of Batavia. The proposed use of this property, 321 single-family homes on 6,000 square foot lots, will be a detriment to the daily operations at the Clermont County Airport. This planned development will immediately impact the operations and the businesses located at the Clermont County Airport and hinder future expansion projects considered for the airport. So a little airport background for everybody. It is important to understand the background of the Clermont County's airport, a significant asset of our county. Dedicated in 1968, the airport is a public use general aviation facility owned by Clermont County. It operates 24 hours a day, 7 days a week, 365 days a year. The airport has a single northeast-southwest runway at 3,566 feet in length, and we accommodate aircraft up to including jet aircraft. The airport is home to over 130 aircraft based, including historical military aircraft restored and based at the Tri-State Warbird Museum, and we host more than 50,000 operations. That's a takeoff and a landing annually, or on average 100 operations per day. Approximately 200 pilots are currently training at the airport, and as reported by the Aircraft Owners and Pilots Association, the world's largest organization, Clermont County is one of Southwest Ohio's busiest general aviation airport. Across the United States, there's well over 5,000 GA airports, and we provide unique services and opportunities for communities. We provide flight training, law enforcement, medical airlift operations, recreational and business aviation, flying clubs, educational opportunities for youth, and specialty aviation businesses. Our airport provides a means for business visitors and tourists to arrive in Clermont County, and the airport is considered a national landmark by pilots across the country. It's home to Sporty's Pilot Shop, the world's largest provider of pilot supplies and educational materials. ECA operates a fleet of 21 flight training aircraft. The flight training services provided all over the globe. We have students from all over the globe, everything from recreational pilot training up through airline transport pilots. And this also includes the students enrolled in University of Cincinnati Professional Pilot Training Program. Aircraft operate to and from the airport under Federal Aviation Administration guidelines, known as traffic patterns. The procedures prescribed to specific altitudes and flight paths to fly when approaching or departing the airport. They consist of rectangular traffic patterns, operate at 1,000 feet or less above the ground. The planned development included with this annexation is located directly underneath the traffic pattern. The FAA enforces grant assurances for airports using federal funding for airport improvement projects. I'll read a couple here that are going to be impacted. Grant assurance number 20, hazard removal and mitigation. Protect instrument and visual approaches to the airport by removing, lowering, relocating, marking, or lighting, or otherwise mitigating existing airport hazards, and by preventing the establishment or creation of future airport hazards. In this instance, the construction of a high-density residential development has the possibility of creating hazards to pilots by increased density of residential lighting near the airport. Also, the creation of stormwater retention ponds will attract wildlife that will impact approaching aircraft. Grant assurance number 21, compatible land use. Take appropriate action, including the adoption of zoning laws, to restrict the use of land adjacent to or in the immediate vicinity of the airport to activities and purposes compatible with normal airport operations, including landing and takeoff of aircraft. The FAA has stated that residential development near an airport is an incompatible land use. This proposed annexation with high-density residential plan development will be negatively impacted by aircraft noise. ECA requests the Board of County Commissioners to reject the petition for annexation. This annexation with high-density plan development will negatively affect the current airport daily operations and future airport improvement projects. At minimum, the county should consult FAA representatives on this annexation to investigate all impacts, present and future, to the airport.
Thank you.
And I know a few comments. I know I wasn't allowed to talk about future, but in regards to the airport, future uses of this property is very important. I look at there and I see 321 homes that can easily turn into 600 homes with the other acreage going to Clough. That would shut us down. And then if this would to go to the village, I have support through county planning commission, through airport zoning regulations. I need to make sure that none of this would bypass any of those present guidances that we have to help protect our airport. Go ahead.
Are there any homes on there now?
On those properties
On the
now,
property that's being annexed, are there any homes on the property now?
not that I know of.
Are you aware what's on the property now?
Last time I flew it over, it was all trees and wooded property.
Are you opposed to any development on the property?
It has to be compatible with airport usage.
So, let's say the annexation is withdrawn or not approved, and it stays in the township, it's still going to be developed, is it not?
Objection calls for speculation.
Well, there's been a lot of speculation and discussion on it, so that's why I'm inquiring this.
As far as the airport's concerned, if it's developed in the proper way and through the proper organizations, I mean, I can work with the township people. I can work with the county planning commission. I can work with the county building department and the zoning regulations.
You can also work with the village of Batavia. Let's say the annexation is approved. And the proposed, according to the pre-annexation agreement, goes forward at some point in the future. We don't, right now, we don't know when that is. But let's say it goes forward in the future. You're going to have an opportunity at that time to state your objections, are you not?
I don't know.
Thank you.
I don't know.
Thank
Bring
you.
up one question. Mr. Gallagher, where is the airport located in relation to the area to be annexed?
Michael, if you could point to it. The airport property is right there.
Runway's right here. Okay.
And we're within less than a quarter mile from those homes, the nearest homes, and a half mile to the center of the subdivision. And
Thank you.
there'll be a lot of airport noise complaints.
Thank
Any
you.
questions?
Is there anyone else? Other comments?
Morning.
Morning.
My name's Mike Hilgeman. The property that I have is at 4349 East Bauman Lane in Batavia. My property is about 7 acres and I'm sandwiched between the airport and the church. My property line is approximately 1,300 lineal feet that would abut their development. So even though I'm only 7 acres, I've got 1,300 lineal feet of area that's right there. When I bought the property 45 years ago, it was a split off of the Clermont Industrial Park. That whole area was industrial, and so I knew that I could develop it as an industrial base any way I wanted, and nothing would interfere with that. We had a noisy business. I had employees coming and going at all times, but we're out in the middle of basically at that time nowhere, and it's industrial, no problem. Since then, I've got tenants now on that property, commercial tenants, and they some of them, for instance, I've got 18 wheelers parked in there. Those guys start their trucks up at 3 a.m. I've got one tenant that wants to put some kind of a logging operation, and we were going to locate it towards the back of the property, and there will be noise. And if there's 300 and some odd residents living right next to me, I don't think it takes too much speculation to realize I'm going to have people complaining, and I'm going to have to defend the right that I have to have that operation there. And I mean, I wouldn't have the wherewithal probably to defend that. So I'm being negatively impacted that way. And we can say that's subjective, but come on, we all know that's what's going to happen. The other thing is, I spoke with my insurance company, and some kind of barrier will have to be put up all the way down through that 1,300 lineal feet. And that's a huge cost that I'm being impacted by. Why is a barrier? Because again, 300 houses, these kids, people are going to be trespassing on that property. And that's not even a guarantee there. My rates will have to go up just to protect against anybody that potentially could be injured on my property. And you can imagine if some of the equipment and tools and I mean, just the operation back there, there's going to be a potential detriment if my insurance goes up, or I've had to defend the right to do what I want to do on that property. Obviously, 45 years ago, I'd have never even thought this could happen. It's industrial. And so I have to oppose it. I'm all for people developing and using their property how they want, but it's going to negative impact me. There's no two ways about it. So I'm against it. Thank you.
Anyone else?
My name is Kyle Bolin. This is my wife, Marie Bolin.
Yep, Marie Bolin.
60 Cliff Pike. We are the most affected of this right here. We're this little notch right here. We counted, and they're going to try to put 9 houses on our property lines. 9 houses. That means we'd have a total of 12 properties touching our properties, including an acre and a half. We just went through a variance to the township with a barn. We had to go to a hearing to get it adjusted to 30 by 40 from 30 by 30. That means that all those property owners would be notified if we had anything like that again. It would only take one to oppose us, right? It's a big issue for us. There's no regard for green spacing whatsoever. And the other legal issue I have here is, so this is our easement right here, right? As you can see, it's half the width right here. That's because when they did the surveying, they put it in the middle. Well, we have a gravel agreement with the current owner. It's a 50-50 rights. So they're trying to annex half of our easement, our legal right to exit our property.
I will additionally add, we are the face of who's going to be impacted, right? We have a 3-year-old son. We recently moved to Batavia a few years ago. We moved here because we liked the community. We liked where we were at. We enjoyed the landscape of the area. We enjoyed the sense of the small community that we were a part of. We also moved because we wanted to have a little more space. We moved from a very densely populated suburb area out here because we wanted a little bit more privacy. Our house actually faces towards the development that's being proposed.
The east.
Yes. We are going to have backyards now sitting directly in our front yard, essentially. So our front yard now is just going to be looking at 4 new properties potentially. We also have concerns for the wildlife in the area as well. We've come to enjoy it, and we enjoy seeing the Ohio area being protected. There's actually a pond back there that, if you see in this plan, looks like it's being proposed to be filled in for additional houses. And it's part of the National Wetland Registry that they're going to be destroying that area as well. That is a pond that's consistently filled in with water the entire year. So we, again, as everybody else has said, we're not against development. We are asking for reasonable development. My son will be attending the schools here soon. I don't want him to be in an overcrowded school. I want him to have the opportunity for the best education possible. We moved Batavia because they were good schools. This potentially can ruin that. And we are hoping that you guys can deny this annexation and go forward for somebody who's going to have more reasonable options for us. Any questions for us? Thank y'all.
Thank you.
Thank you.
Anyone else?
Hello.
Hi, my name is Michelle Snyder, and I live at 1783 Cleft Pike. I am one of the surrounding area homes within a half mile. And just to add on what you just heard, we moved to Batavia Township because we have some space up on Cleft Pike. The homes are between 1 acre and 5 acres, and that's what we enjoy. We enjoy that the township takes seriously what can go in around us. The village is jumping on that and taking advantage of property owners that are willing to negotiate on that and to create something that isn't in line with what the property owners in the area envision. I understand that we have to look at the benefit versus the detriment, but I would question, what is the benefit? What is the benefit? We've heard a lot about the detriment, but not a lot about what is the benefit. I think, in my opinion, the benefit comes solely to the village because they can increase their number of residents. And in my opinion, their goal is to become a city, which is why they are pushing for things such as this, overloading the schools, causing traffic issues. If the commissioners cannot deny this, I ask that you explain why you can't deny it. And I ask, maybe we look at legislation. We've heard the attorney say, you can't look at what the schools say. You can't look at future plans. I think that that's an issue. I think that's a real challenge that our state legislature needs to look at and change, because right now it seems like the laws tip in the favor of the municipality at the expense of the townships and the township citizens. And most people live in townships these days. We need to protect that. So I oppose the annexation, and I appreciate your time.
Thank you.
Thank you.
Thank you.
Anyone else?
My name's Brian Wanstrad. My address currently is 225 Sioux Drive. Previous to that was 1708 Cleft Pike. My wife and I and 4 kids moved back from Arkansas back here. Lived at 1708 Cleft with my mother and father-in-law, 4 kids, 8 and under, so they thoroughly enjoyed that time. However, if I may walk up to the screen there. My wife and I and kids plan on residing on this piece of property here. In-laws purchased it, 17.5 acres, purchased it from the current owner of one of the 3 properties in question. Obviously, I'm opposed to it. And what I have to say was kind of put together here, listening to the testimony and all that other stuff. So bear with me as I try to go through it. So some of the things that can't be used in courts or what have you to oppose an annexation. Actually, I feel, I don't want to say offended, but I kind of feel like the other side was annoyed with our opinions on why we oppose this annexation. And maybe it was meant to be that way. Maybe it wasn't. Maybe I misunderstood it, but I felt like it was an annoyance. And some of the things he had listed off are what he's heard before. But maybe there's a reason, because it affects people like us. And I understand precedents and previous court cases, but if you reference Greene County, that's not Clermont County. It's not Batavia Township. And you can't reference schools, but a superintendent is here. You can't represent taxes, but we address the tax issue where the residents of these houses here won't be paying for the services everyone in this room will if you're residing in township. My question to the fire chief, and am I allowed to ask the fire chief now that I'm here? It was just a no. You can't?
No.
Well, shoot. Well, I'll tell you from my experience, I'm a retired firefighter, 26 years. 16 of it was in Hamilton County, so in this area. The governor I asked the chief about withdrew state and local funding to fire departments, and it was a big chunk of money that the governor took away from all local fire departments. So in the chief's testimony, he was up here, he was speaking on how are we going to fund it. I was part of Delhi Township Fire Department where the fire levy failed in 2004, laid off 55 part-time guys, shut down 2 fire stations, and we ran out of 1. That's not a precedent in Greene County. That is what happens. That is not argued in court. That is at-home politics. And I don't mean to speak to the fire chief. I've never worked with him. So I don't want to put words in his mouth, but he will have to deal with that. It doesn't matter what court cases say. If the voters vote down any type of increase in taxes, he has to deal with it. So if you have a governor taking money away, then you have an annexation where the people who would potentially live in these homes aren't fulfilling their side of the tax burden of the Central Joint Fire District. Yeah, it's going to affect everyone here, but the firefighters will be affected in the sense of how are we going to make it work? It costs money. As far as future development, I can understand not speculating. However, they provided that. That sure looks like future development. Now, I understand it can change. The last 2 years of my firefighting career were in the fire marshal's office, and part of that's in Fayetteville, Arkansas. We're plan reviews exactly like this. So these do change, not very much, but you can't use the future, but you can pretty much have a good guess of what it's going to look like. I don't foresee, if it is approved, much of a difference here. You may have to move some streets. All kinds of codes are applied to these things, including the fire code, which is what I applied when I did these plan reviews. So I understand that the court says you can't use it, but when are we going to get away from that? Because everybody here cares. The precedents set in other court cases, I get, but use it. I mean, I don't understand why we can't. And if the superintendent of a school says this is going to directly affect this school, I don't understand why you can't. You have the ability to say, like, well, we can't consider it. Well, why not? because it will affect everyone here. And it isn't fair that the people in those potential homes aren't going to have to pay for the protection. So there's taxation without representation. It's kind of the inverse of that, I guess, because they're not going to be paying taxes, but they'll be represented by the joint fire district there. Let's see if I have anything else here. As far as the airport, if I can approach that again, the director was talking about the traffic patterns and the rectangular traffic patterns. So one part of that rectangular traffic pattern, what he was referencing, is the runway runs this way. The rectangular pattern runs around the outside of that airport. So that gives the pilot time to adjust his altitude as he comes into land. As he's flying those patterns, he's looking left and right, getting his orientation, make sure there's nothing in the way. If you look on Google Maps currently and zoom in, you'll see a plane right here. I'm assuming based on his direction, he was on a downwind approach. So he was flying parallel to the runway. He's going to make his turn, which is base, and then he's going to turn and make his final approach and land. So there's an airplane on Google Maps right here. And as the director talked about, there's all kinds of obstructions. Sure, you can see a tall tree or telephone poles. Let's apply the federal regulations. And they say you got to lower it. You can't regulate geese. Whatever other bird decides to land in these five ponds. A commercial airliner crashed on the Hudson River in New York City, and I would potentially argue there may be more geese at these 5 retention ponds than out there in New York. I'm not saying it's guaranteed to happen, but aside from precedents of court, I feel like you just have to just boil it down to what's fair and just common sense. 5 ponds that are going to harbor any type of waterfowl or something that flies can get in the way of these airplanes. And I don't want one landing in my backyard at all. And I'm sure nobody does. It will affect the school, or I don't think the superintendent would have been here to talk about it. It will potentially affect the Central Joint Fire District and the response times. And that's very true. The chief can tell you, run numbers are only going up. And it's harder and harder to staff it monetarily. And it happens all the time. You get 2 and 3 calls back to back. If there's no one at Central Joint, I'm not sure who their mutual aid partners are or where the next closest one. It will affect all of the things that the first attorney to speak says we can't apply to the denial. And I don't want to be in your guys' seat. I certainly don't, but I don't understand why they can't be applied. I truly don't, because I can't think of a single benefit for any of the surrounding property owners or anyone that's got to drive past it, or anyone's got to deal with the traffic of all those vehicles coming out of there. And I think that's it. I think I wrapped it all up. Sorry if I jumped all over the place, but I had to try to put it together as quick as I could. Any questions?
No, sir. Thank you.
You? No.
Yes, sir.
It's appropriate for me to follow him. He's my son-in-law.
Somebody asked me if he enjoyed when we lived with him under oath.
No questions, please. I'm Ray Nizer. My wife and I are currently the legal owners of that piece of property that Brian was referring to. We helped to secure that property for their future building plans. Them, and I should say they're my 4 grandchildren. But anyway, I actually live right down the street. I think I'm within that 1/2 mile perimeter around the proposed annexation. I live at 1708 Clough Pike. We've raised our family there. We've been there for just about 35 years now. And all of the development that's taken place on that north side of Clough that we're on has all been slow, controlled, gradual, and really nice. I mean, it's relatively large lots with people able to enjoy their privacy, as we have for those 35 years, and as we intended for my daughter, son-in-law, and their 4 grandchildren on that piece of property. So I have a lot of concerns. I thank Mr. Roach for his pointing out that that's not a future development. That's on the table. That's in there in legal documents. And I'm concerned about it, very concerned, because for one, just one simple thing, that property that I'm referring to, that we're the current owners of, is hunted by Brian, for one, and we've already experienced a problem with trespassers on the property while he's in the blind hunting, and I'm really concerned for the safety of those many residents there, or their kids, who may wander into those woods while there's somebody actively hunting during hunting season, of course. So that's a safety concern there. Also, I'm very concerned about traffic patterns. Gosh, in those 35 years that we've been there, well, it was next to nothing on Clough Pike then. It's grown. I'm okay with that. I mean, we've had controlled growth. And there's a significant increase in traffic as it is. This represents, wow, a kind of an explosion of traffic on Clough Pike, and I haven't heard any plans to really deal with that in a good way. As I look at this, not accusing anyone, but my impression is that this is all greed driven. I mean, the developers are certainly behind this. They've worked with the village to try to get this in so they can circumvent the responsible reviews by the township when development is planned. One of the nice things about development planned by the township in the area is that I have a voice. I get to come to those hearings. I'm a resident of the township of the township, not the village. I'm really concerned that any hearings or anything. Well, I think a lot of it's already been green lighted. I think, but I don't feel like I'll have the same voice in trying to hold the representatives accountable for responsible development in the area. So I'm very opposed to this. I just don't think I think it is a detriment. I think it will affect my property value. And I guess that's about all I have to say. Thank you.
One question. So, sure. Do you have a position on this entire area being tax abated as a surrounding property?
It's awful. So to your point and to Brian's point, it means, okay, they're not going to get the additional funding for the schools or for the fire. And that means one of two things. One is that we have to cut the level of service, and really, or find some other way to raise more money to pay for it, which means more taxes to the rest of us, which that makes no sense. Again, a detriment to us. Thank you.
Thank you. Anyone else?
Sir?
I'm John Jack, 1775 Clough Pike. I'm within that targeted half mile range on the inside. Like the other gentleman that just spoke, I've been out there approximately 25 years and have seen what has largely been controlled development, somewhat responsibly sourced. While speculative development and deals like this are something that I have been professionally familiar with for some time, I agree that there is very little likelihood that development plan changes effectively over time. The largest objection that my wife and I have to this is that while the township or the village may take over the care and the feeding of the small strip of land in front of the property, the maintenance of the road, we already have a situation on that end of Clough that has too much traffic in too small of a corridor, with semi-trailers now coming through due to some other commercial development that was offset closer to the airport as a means of cutting through. We have that all mixed in with school buses in the afternoon, and now to add 300 high-density homes, not to mention the additional problem that we're going to have with 10 to 15% roughly downside risk to our property valuation. Again, we're not anti-development. We're not anti the inevitable march of time out here in the township. But we do object to paying taxes for things where sweetheart deals for developers have been slid through. And yes, we can't speculate. Yes, the Ohio revised code, et cetera, et cetera. We have a feeling personally, and I space this on my own, I think this has been somewhat disingenuously presented as something that we somehow couldn't object to over time, because we are residents of the area, we do pay taxes, and we are responsible for trying to, as a group, maintain some sort of rational development in and it affects our children and our safety. So, sorry, thank you.
Thank you. Anyone else? Good afternoon, Rex.
Hello, Commissioners. I'm Rex Parsons. I'm a Batavia Township trustee, a resident of the community, of course. And I want to talk to you about something that really hasn't been brought up today, and that's morals. And I know as elected officials, we all strive to do what's right for the community. We've heard from a lot of residents that live in the community. There are residents that are going to be affected by this because of using the CRA is going to redirect funds away from several agencies. Some of those agencies come up in front of the county commissioners and ask for permission to put levies on the ballot. I received an appointment, not from this board, but from a previous board, to sit on the MRDD board. I have a soft place in my heart for those folks. You know, they either didn't get an extra chromosome or they got too many, but they depend on us. Our moral obligation is to protect them and to give them the things they need to have a life, as best life as they can. And this CRA is going to take funds away from them, those groups of people, as well as the additional folks that come up here in front of you and ask for your permission to put those levies on the ballot. So I am opposed because not only as my prior time as a MRDD board member, but also as a trustee, by using this mechanism, which I guess is legal, but I think it's morally wrong. And that's where I draw the line. And that's where I would stop and say, hey, wait a minute, is this the right thing for the community? And because of that, I'm going to ask you to consider that this is really not to the best interest of our community. And it's not just the people in Batavia Township. This is the people in Clermont County as well. And that's why we're here. Any questions? Thank you.
Anyone further?
Hello, Commissioners. Thank you for letting me speak today. My name is Michael Wolf. I live at 921 Surrey Trail in Clermont County. I've been a Clermont County resident my whole life, the CEO of the airport. I've worked my entire career, except for a short time with Mr. Painter and Zimmer, but spent my whole life at Clermont County Airport, a jewel in the community, a very important piece of the Clermont County to bring industry in. I hate to see the encroachment on the airport that puts the airport at risk. We've seen Blue Ash airports closed. As Chuck said, it's not compatible with the FAA for airports. We need to protect the airport for the infrastructure to bring business and jobs into this area. The only positive thing that I see from this is money for the owners. Of course, people like to make money, but also for the village. And that's it. Everything else is negative. It negatively impacts everything in the entire area surrounding that. So I personally, as a resident of Clermont County, am just totally opposed to this subdivision. Thank you. Questions?
Anyone else? Yes, yes, you can come.
I've been trying cases in front of juries for 45 years. I've been doing these annexations for about 50 years. And the reason I did not cross-examine any of the citizens is because in a lot of those situations, I've tried cases, the attorney has to vigorously represent his client no matter what. And a lot of times that turns people off. And I respect all you folks here because I respect your positions. I can't say I would blame you if I were you, but I didn't want to incur whatever you have against me, what I've said today. I don't want to create any or exacerbate any ill will between you folks and the village of Batavia. I am here representing private clients. I am not represent the village. So I want to tell you, I respect all your positions. I've heard it many times before. As a matter of fact, I owned the lot next to my house because I didn't want anybody building a house on it. So I know what you're saying. I have nothing additional to say other than when council said my interpretation of Granville case was not the truth, I would kind of object to that language. When attorneys disagree on a case, it's a disagreement as to interpretation. When it says it's not the truth, that somehow I take offense to that. So we interpret the case differently, apparently. Lastly, and I might be accused of sucking up, but I want to commend the clerk and your staff because every time I've come in here on numerous occasions, they've always treated me with respect, courtesy, professionalism, and efficiency. And I always look forward to coming over here for that reason. Thank you.
Sir, I will just add to that. We have very, very good employees here, and we're proud of each and every one of them.
Yes, we are.
Thank you.
Okay.
That's for them.
Thank you.
Thank you. So at this time,
I'd like to interject here. We did receive correspondence. I don't know if the county engineer received any correspondence. Okay. We did receive correspondence here at our office. It was an email, and it was from Eastern Cincinnati Aviation addressed to the board. And Mr. Gallagher did actually read his letter here today, so he addressed the correspondence we received.
One thing before we close on behalf of the township, I'd ask, thank you for your time. Thank you for your consideration of the evidence and the arguments put forth before you. Don't mean to accuse Mr. Manier of being untruthful. You're correct. I disagree with your interpretation of the case. I'm not insinuating that you're being untruthful. I'd ask that exhibits 1 through 5 you have in front of you, I've asked that those be admitted for consideration by the commissioners. And that's all. Thank you.
Thank you.
I would, Commissioners, Brian Shrive with the prosecutor's office, assistant prosecutor in the civil division. I just want to, there's one point of clarification. I thought it's important to note that I don't know that it necessarily has any bearing on the decision, but I think it seemed that this was a bit of a point of contention. And I think respectfully, I think both attorneys are incorrect on this point of law. And that is that the annexation, if it is approved, and I take no position whether it should or should not be, if it is approved, would not automatically serve to exclude that territory from Batavia Township. So the property owners and residents of that territory would continue to vote on township trustee races, would continue to pay township taxes. And the township would continue to get whatever inside millage. And that is based on a case from an Ohio Supreme Court case, 2019, State XREL St. Clair Township Board of Trustees versus Hamilton. It's 156 Ohio State 3rd, 272, 2019-Ohio-717. And so that's just something I think that may.
Sorry, could you repeat that, please?
Yes, that's State XREL St. Clair Township Board of Trustees versus Hamilton. 156 Ohio State 3rd, it's 3D, 272, and 2019-Ohio-717.
Thank you.
So that is, I don't know that that necessarily has any bearing one way or another on the decision, but I think there was, it seemed like there was some concern of that issue, and I thought it'd be appropriate just to kind of help allay some of that concern, perhaps.
If there are no further comments at this time, we will close the public hearing for the proposed amended annexation. The disposition of the petition can be today if the Board of County Commissioners so choose, or within 30 days of this public hearing. And that is that's pursuant to and in compliance with section 709.033 of the Ohio Revised Code.
okay. Commissioners, at this time, I would like to have the 30 days. We've gotten a lot of information here today. I would like to have the time to go over, review.
Yeah, it would be my recommendation to the board to go ahead and deliberate. This is a hearing, not a meeting. So you don't need to go into quote executive session. You can deliberate privately for the purposes of this hearing without an executive session. And to discuss it, come to a determination, whether it be today or between now and the 30 days, and we can help the prosecutor's office can help prepare the actual written decision for the board.
Commissioner Painter, do you have anything?
I would just defer the decision today to a date later within the 30-day time frame. I would not suggest to deliberate, walking away from this board and deliberating or discussing anything that would affect this annexation and or the people that live in this would not be genuine. You know, so anything that we would discuss, I would recommend it's discussed right out here on the board.
I concur.
So
Okay.
are you agreeing then
you.
that we should have the time to?
30 days.
I would.
Okay. Do we have to do that by motion, Brian?
No.
I
To,
think you just close the hearing and
okay.
I would act on, I believe there was a motion to strike some testimony that was made. My recommendation would be to deny that motion and allow the testimony and give it whatever weight it deserves.
The motion to strike was regarding Jeff Hayes'
Yes.
testimony, and Mr. Manier objected.
Well, that was an objection. The motion to strike was, I believe, as to Ms. Schwartz's
Okay.
testimony.
Ms. Schwartz, all right.
And so I think because there are relaxed standards of evidence in these hearings, to allow the testimony and the board can give it the weight it deems appropriate.
We need to do that by motion.
I think, yes, I think that should be
Or do I have a
agree
motion to?
to overrule the motion to strike.
Motion to overrule.
I'll give you a second on that one.
Roll call, please.
Commissioner Painter,
Yes.
Commissioner Corcoran,
Yes.
Commissioner Batchelor.
Yes.
Okay. And then there was a separate motion. There was an objection, but I think we really was kind of taken care of in the record with additional questioning. So I don't know that the board needs to act on that. And then I think there's the motion to admit the exhibits into evidence. Again, I would think that my recommendation for the board would be to accept those into evidence, give them the weight they deserve. That the board.
All exhibits and testimony will be entered into the record today as moved.
Okay.
All right, I'll give a second.
Second.
Roll call, please.
Commissioner Painter,
Yes.
Commissioner Corcoran,
Yes.
Commissioner Batchelor.
Yes. So,
And then we would close and render a decision within 30 days.
Yes.
Not-
Yes, we were. Actually, I closed the public hearing just a few minutes ago.
I think technically we're closing it now. Right?
Yes.
Yeah, but you
Okay.
have, there's a question or something here, or I don't know.
The review over the next 30 days, is that all going to be behind closed doors, private, or is the public going to have
Private.
any access?
That's the board's private deliberations.
Mhm.
That's a private.
but we will
Not together.
discuss it
The
when we
decision
come
will,
out.
the decision will be released publicly. Yes.
Right.
Okay. So
Okay.
30 days from today?
Yes,
Yes.
30 days from today.
Within 30 days.
Within.
Within.
What will be the mechanism of release?
Here in session,
It'll be out.
there'll be a resolution here in session. And that you can find on our website. Any of the draft agendas will be there. But we will notify the township and the village of when that resolution will be available. Okay?
Okay. And I want to thank all of you for coming. It's nice to see residents who care about their community and want to come and give their input. Thank you.
Thank you for your time today.
Thanks for coming.
Thanks.
Yeah. So whoops,
I was looking at-
Move on.
what?
Oh, I thought you said.
He just always gives me mean looks.
I don't know what's Beck saying.
Thanks,
Close the
Mike.
hearing.
Where the airport can get
We didn't
notice
close
of when
the
that
hearing.
will be.
No.
Sure, sure.
Yeah, she did.
Sure.
She
I've got
did.
you right here.
Okay, that's
Okay,
perfect.
all right.
Because we're not the property owner.
Exactly. We know.
All
Yeah.
right.
Thank
very
you.
much. Just let them clear out.
I'm going to.
Julie, was it okay? Okay. I just want to make sure. It's my first one like this. Okay. Hey, we're back in regular world.
We still have to close the meeting.
We still got a little bit
Yeah,
to
Yeah,
do.
still on
we
set.
do.
Just go ahead.
Okay, we're going to continue on. Okay, moving on to item J is member comments. I want to remind everyone that our offices will be closed this Friday in the celebration of Veterans Day. We're going to hold on just a second.
Yeah.
Again, offices here at the county will be closed this Friday due to our observance of Veterans Day. And then on Saturday at 1 o'clock, if you've never been to it, at the Union Township Park, the helicopter park, they put on a wonderful service there in remembrance of the veterans. And then Sunday on I guess it's the courthouse steps, right?
Yep.
At 1 o'clock, there will be a service there. And then immediately following, I've been told it's around 2 o'clock, there will be a parade. So hopefully we get to see a lot of people out this weekend celebrating our veterans.
And don't forget to light up your residence or your business in green. You know, have your green light bulbs on for Operation Greenlight to bring attention to veterans benefits for those who have so honorably served.
Commissioner Corcoran, anything?
Nothing, thank you.
Okay, then item K, I would accept a motion for adjournment.
So moved.
Roll call, Gail.
Commissioner Painter,
Yes.
Commissioner Corcoran,
Yes.
Commissioner Batchelor.
Yes. We will see you next
Thank you.
Wednesday. Thank you.